has a deep cut connection right there. Yeah. You have probably not been to one of these. Okay. Yeah. We use this stuff like that's how it's recorded. Good morning.
I'll try again. Good morning. Morning. Welcome to this standing room only public hearing on risk-based provider organization and ACO appeals. Joining me is David Seltz, Executive Director of the Health Policy Commission, and Lois Johnson, General Counsel of the Commission. The purpose of today's hearing is to receive public comment on the proposed regulations 9958 CMR 11.00 internal appeals process and external review process for risk-bearing provider organizations and accountable care organizations. The state legislature charged the Health Policy Commission and the Office of Patient Protection with promulgating regulations for the external review of appeals by and on behalf of patients of risk-bearing provider organizations and accountable care organizations. The statutory requirements are Mass General Law, Chapter 1760, Section 24D and E, internal appeals process for risk-bearing provider organizations, patients' right to third-party advocate and external review process, and Mass General Laws, Chapter 6D, Section 16.8B, the Office of Patient Protection Powers and Duties, External Review Systems. Today, any person wishing to record today's hearing must speak with the HPC Deputy Chief of Staff, Erica Savelli, prior to doing so. This hearing is being recorded by HPC and will be posted online. A sign-in sheet is at the door for those who wish to present oral testimony. The HPC will determine the order of testimony, and parties may provide oral testimony only once. Please focus your testimony on the proposed regulations and limit remarks to 5 minutes. Remarks made by groups of more than 4 will be limited to 10 minutes for the group. Those presenting oral testimony are encouraged to submit written copy as well. Written testimony is accepted until 5 p.m. today via email to hpc-testimony@mass.gov. Parties unable to submit electronically should deliver their submissions to Lois Johnson, General Counsel, 50 Oak Street, 8th floor, Boston, Mass. 02109. More information is available on the HPC website. All testimony today is given equal weight, whether written or oral, and all written and oral comments submitted to the HPC may be posted on HPC's website and released in response to requests for public records. As is customary, elected and appointed officials are taken out of turn to offer testimony. When called to testify, please state your name and identify the organization you are representing. And we have one individual and one organization that is signed up to testify. So with that, I'll call Wells Wilkinson of Health Law Advocates.
So good morning. Thank you all for this opportunity to speak about these proposed regulations. I'm here on behalf of Health Law Advocates, and along with Healthcare for All and Mental Health Legal Advisors Committee, will be submitting comments later today in written form. But I just wanted to say a few things that kind of, better kind of describe some of the principles that we were thinking about in writing our very detailed comments to kind of communicate some of the broader concerns. First, I want to thank the Commission issuing these regulations with a lot of detail. I think that kind of granular detail is very important, both because the ACOs are not like insurance carriers, they have not been handling internal appeals and external appeals to the extent that they do for a long time. So more details can help to get this system up and running faster. And I think more importantly to us, it's also going to help more clearly demarcate the kind of obligations that the ACOs have and consumers have to participate in the process with respect to details around deadlines and sharing information, medical records, etc. We certainly understand the big picture here. The ACOs present an opportunity to try to rein in wasteful healthcare spending, right? And I know from my 8 years of prescription drug fraud work before I started at HLA that we spend tens of billions of dollars on needlessly expensive brand name drugs when they are equally effective generics available. And without doctors having the financial incentive, the choices have no real meaning to them, right? So the ACOs present a real opportunity to kind of check some of that waste. We also see at the HLA that there are real problems with the insurance system now where providers will either provide services or they'll request authorization for services, and the insurance carrier will become a barrier and say, that particular service is not covered under your plan, or we think it's not medically necessary, even though those administrators and the insurer have never actually examined the patient, right? So, this kind of global payment system can solve a lot of those gotcha problems that oftentimes leave our clients waiting months for approval for treatment or leave them with medical debt when something is provided and then not covered. So, we think there are real promises here with the ACO system, but we also are concerned that there's this significant shift that providers are playing in this change, right? When the private insurance appeals, I often work with I always work with my clients, and we often work very collaboratively with the providers to gather medical records, to gather a medical opinion letter, and submit this in support of the appeal. When I don't have that kind of support from providers, it's almost impossible to win an appeal on medical necessity if you don't have that provider working with the client, right? So in this new context, the provider and the client are actually in some kind of dispute about what kind of treatment or referral is appropriate. And so we feel that in this context, we really need to make sure that the appeals rights and the system of those rights is especially robust, because that's going to allow the patient to have a real kind of fair say in the decision around this dispute. So toward that end, there are just kind of 5 brief things that we'd like to see the appeal system include. One would be allowing consumers ready access to their medical records, right? That will allow them to kind of understand the full scope of what is understood by their provider at the ACO, and give them kind of equal footing to assess that, and also to understand what their records show. They also need ready access to outside medical opinions, including coverage by their health plan for those independent opinions, because you can't expect a consumer with no medical training to argue the medical appropriateness of the referral they want with their doctor who's got years and years of training. Right? That's just not going to be fair. And in this process, we also ask for flexibility, because we know when consumers request medical records from their outside providers, hospitals, doctors, it can take a month to get them. And sometimes that's even difficult, even though there are clear rights to them by federal law. They also, if they wanted a second outside opinion, arranging that can take time as well. So we ask for flexibility in the application of the deadlines for either the internal and external appeal process to allow consumers to get access to these other independent medical resources in support of their request. And last, I'll just return to the issue of requesting that these regulations and any sub-regulatory guidance that accompany them be very detailed to provide clarity to both the ACO and the patient about what their rights and obligations are as this process goes forward. I could envision this process not being nearly as confrontational as the one is between consumers and their insurers who dispute over economic service, right? Because it's the patient working with their regular treatment provider. and they have a dispute, but they want to try to resolve it in some amicable way. So, in this context, I think there's a lot of room for collaboration and negotiation at times, but not always. And so, I think it's important that in that generally friendly environment, the ACOs clearly represent to the patients what their rights are. Right? So they're going to be going to them asking for, how do I disagree with you? Okay, what's the process? And so in this context, we would strongly recommend that the Commission and OPP create model forms, model disclosures that the ACOs can use so that everything's uniform and consumers are not misled. In comparison to consumer appeals, I see health plans all the time that put the word final in their decision for their internal appeal, and then misleadingly put it up there prominently in the front, and it dissuades people from understanding they have a right to an external review. Right? And so it's very deceptive, very misleading. And I think model notices from OPP could help make sure the ACOs don't potentially, or probably more often, inadvertently mislead someone. Oh, and the last thing we ask is that in this context of disputes over what kind of treatment might be appropriate, the patient could be in an ongoing course of treatment, or they could be waiting for treatment, and they're disputing which one would be appropriate. And in this context, we would request that OPP and the ACOs and the external review organizations all work together to create the kind of technological practices that allow consumers to submit things instantaneously through online portals or through email, and also to receive decisions instantaneously as well. I see consumers who receive decisions on their internal appeals from insurers, and the letters dated one day, sat for a week before they even mailed it, and then it took 4 days to arrive. Right? So by the time it gets there, it's old news. And if someone's waiting for treatment, there's no reason to make them wait 3 or 4 days for a letter in the mail to arrive when a phone call would be prompt, an email would be easy. In many cases, the ACOs may have phone numbers and emails for the patients at point. So that concludes my remarks. We'd be happy to continue to work with the Commission on how to incorporate some of these suggestions into the draft rules and finalize.
Well, thank you. And please make sure we get the written testimony. Next, we have Susan Kendall from Mental Health Legal Advisors.
We are submitting testimony jointly with Health Law Advocates and Healthcare Law. And thank you for having this hearing. I just want to emphasize 2 points. One has to do with notices. We believe that it is very important that people are given their notice of a right to appeal at the time they are denied the service. We all get notices when we go to the doctor's, privacy notices, notices about who's liable for what expense at what time, and none of us, or very few of us, I must admit I sometimes do, read those notices. And so it's important that the notice be given when it's pertinent to the individual. This means that the provider, at the time they're telling the patient that they don't agree that the person needs a particular service, that's when the person should get their notice of appeal first. It's not going to take much time to hand somebody a piece of paper that gives them their opinions. The other thing is that there needs to be coverage for an independent second opinion. Honestly, nobody is going to win an appeal if they don't have a medical expert presenting evidence in opposition to the doctor's decision to deny care. And this is what makes ACOs so different from other delivery forms, fee for service, because the provider is not per se on the side of the patient. There are shared savings, there are bonuses, there are all sorts of things that may influence however much the provider's decision to provide care. There's also, with our clientele, people with psychiatric diagnosis, there is implicit bias against persons with psychiatric diagnosis and a ton of evidence showing that they don't receive the same physical health care. And it's not because of access issues, but because of implicit bias. They don't receive the same physical health care as people without psychiatric diagnosis. So having that free and independent second opinion is vital. Otherwise, really, the whole appeal process is flawed because it's almost impossible for anybody who doesn't have the luxury to have the funds to pay out of pocket for a second opinion. It's impossible to appeal.
Thank you, Susan.
Thank you.
We'll look forward to your written testimony as well. Seeing that no one else has signed up, is there anyone else in the audience who wishes to testify at this point? Not hearing or seeing anyone, I will call the session, the public testimony session adjourned. I want to thank all of those who offered comment. Again, a reminder that written testimony is accepted until 5 p.m. today via email at hbc-testimony@mass.gov, or electronic or written comments can also be sent to Lois Johnson